Hi, this is Rajiv. Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC, immigration.com. I'm just making a quick comment about a ruling which was announced today by a federal court in Northern District of California. Today, December 1st, the court threw out both the Department of Labor regulations, which tremendously increased wages, and the H-1B regulations that were going to come into effect in about 5 days, 6 days' time, where they were redefining employer-employee relationship, reducing the third-party site placements, client-side placements, H-1Bs to 1 year. Court has said both these regulations are unacceptable. They were promulgated without the proper procedures, and the excuse the government used to circumvent the proper procedures for rulemaking were not acceptable. Government had argued in a nutshell that we have to act in a hurry, and the court said, well, you've known this is a problem for months and months and months, and all of a sudden you act and you try to circumvent the normal procedures, not giving people enough time to respond, not taking enough time to consider. So the court has invalidated both regulations on a procedural matter. But I personally think, even though in this case it was not necessary, if these regulations were promulgated again, which is unlikely, they will be susceptible to a challenge on the merits themselves, because the statute simply does not permit the results that the government wants to achieve. So normally what happens is when you go to a court, the court will assign the easiest, most uncontrovertible reason to revocation of a regulation. In this case, it is easy to determine that the proper methods were not followed. Okay, this is all you need to know. Now, in a couple of days, we should be coming back to normal. Department of Labor should be rolling back their wages. We should be able to rely upon flcdatacenter.com for wages as before. That should all be rolled back by the Department of Labor. I expect maybe like I said, in a couple of days. If you are interested and you want to look at the decision, I am going to make some comments. I have, of course, reviewed the decision. There are some citations that I truly like, and these are good things to remember. One thing I like the best is, listen to this quote by the court. The history of the United States is in part made of the stories, talents, and lasting contributions of those who crossed oceans and deserts to come here. The national government, which is Trump's administration, has significant power to regulate immigration. With power comes responsibility, and the sound exercise of national power over immigration depends upon the nation's meeting its responsibility to base its law on a political will informed by searching thoughtful, rational, civic discourse. So you cannot change laws with the power of a pen, and you must always have sound policy. Government in this case argued in part that, oh, there is a huge unemployment, and the court said no, the figures don't agree with that. I have been arguing for days, and of course anybody who can think about this area of the law would argue the same, that if you say there is 8% unemployment or 10% unemployment, you are really lumping together apples, oranges, horses, carriages, cars, automobiles, all in one basket. It doesn't belong there. A neurosurgeon is not looking for a job as a dock worker, and a dock worker is not looking for a job as a neurosurgeon. So therefore, this lumping together of all classifications in one is just not suitable. And the court then also made some comments about, you have known about this for a while, Department of Labor especially. The studies that they cited, I'm actually quite concerned about those studies because I think they are faulty, and they are also susceptible to definite challenge on merits. That said, I can go over the ruling, the main areas of the ruling, and just kind of make some comments about the way I saw the case. Let's see. So these are just random comments. They want to know that the government has given due deliberation. You can't just helter-skelter throw out regulations. And the court did not find that. At least it was not properly presented to the court. They talked about the presidential proclamation. And the court said, the presidential proclamation, I have made this comment in a couple of forums, in public forums, that the proclamation on which the government was basing these two actions has itself been thrown out by the court. So, for that purpose at least. So, it doesn't make sense for them to rely upon it. And I like what the court says here. They say, defendants' response to this court's ruling on the validity of Proclamation 10052 appears to be an embodiment of the adage, if at first you don't succeed, try again. Appearances can be deceiving. So the court didn't buy it. They said, you are basing this entire set of regulations on false premises. Then we go on. They also noticed that specialty occupation had remained unchanged since 1991. When government wants to change a regulation that has been in existence for so long, they have to come up with better logic and better reasoning than just saying, well, that's because President Trump asked us to do this. And then they talk about the levels 1, 2, and 3, and 4, how the government just randomly affected they changed the percentile and they raised the regulation, the amounts by such large figures. And then we go on to, there are various observations made by the court. The court looks at the decision, make sure that the government has used good cause rationale for the good cause exception, where they are trying to change the regulation without giving us any notice. And the courts, of course, found that there was no such reason. And I like, again, this language. The exception is to be narrowly construed and reluctantly countenanced. That indeed is true. Otherwise, the agencies would never give us notice. Everything would be made urgent. They also, like I said, they talked about delay, that you sat on this problem for 6 months. Now all of a sudden, when Trump is leaving town or elections draw closer, you are actually, this is before the elections. They were trying to prove to the court or to the people that Trump has done a lot of damage to the H-1B program, and he did, but this was more politics than policy. Then they talk about the studies. I definitely think the studies are themselves up for challenge. And again, this is where they talked about you can't lump everybody, all the jobs together in one basket. So they said, in the area that you are trying to cover, the bachelor's degree people, the rate of unemployment was 4.8%, not 10%. And also, this is very interesting. The court said, look, the government has not even said that this is a temporary problem and these regulations are temporary. You've not said that. It looks like you're trying to change the law permanently. Court didn't say that, but that's what is meant. Defendants did not suggest in the rule or at oral argument that they are intended to be a temporary solution. So they didn't say that. So therefore, that itself makes it quite suspect. And that's pretty much all I wanted to cover. Basically, one of the weird arguments Department of Labor was trying to make was, if we give the employers too much notice that we are changing the wages, the employers will immediately file for H-1B extensions for 3 years, and they'll be able to use the lower wages for 3 years. And the court said, that's nonsense. You have no evidence of it. This is just your predictive judgment. And I'm not sure if this was argued, but my argument would have been, I can always use private wage sources. I don't have to rely upon the government sources. That option is always available to me. So how does it matter how much notice you give me? I have other options. Your giving of the notice does not change me, the employer, my behavior in any appreciable manner. Anyhow, the court didn't buy this argument. Oh, I also like this line, that we must ensure that the exception does not swallow the rule. And that's exactly what the government was trying to do. They were trying to do away with the notice requirement by saying, oh, there's an exception. But this exception truly swallowed the rule because it didn't exist. There really was no exception. And the problem they've been aware of since 2017, even before COVID. So that was, ladies and gentlemen, that was the ruling. I am quite happy with it. I think this is the proper result. I'm just sorry that it came so late. I wish we could have gotten an earlier ruling, but the wheels of justice take time. Nevertheless, congratulations. I think we are good to go. We should be seeing a reversal by the government within the next couple of days. Good luck.